Hello and welcome everyone. Thank you very much for tuning in. This is a screencast-o-matic presentation for Unit 2, Lesson 5. In this particular lesson, we're going to be looking at contemporary issues in American culture and American modern history that show us and tell us why the Bill of Rights matter. And we're going to be looking at certain situational cases upon which there might have been violations of the law and or violations of law enforcement interpreting the law. Please remember that for this part of the presentation, or any part, you can replay for clarity or detail if you need. Please also remember to answer the key concept questions that come with each contemporary case, as we'll begin to understand more about how these amendments work in action. Let's go and get started with the first reading. Police seizure of text messages violated the Fourth Amendment, a judge rules. But legality of warrantless cell phone seizures is still unsettled nationwide. At 6:08 a.m. on October 4, 2009, Tricia Oliver frantically called 911 from her apartment in Cranston, Rhode Island, when her 6-year-old son, Marco Nieves, stopped breathing. The fire department took Marco to Hasbro Children's Hospital, where he was found to be in full cardiac arrest. He died 11 hours later. By 6:20 a.m., Sergeant Michael Kite of Cranston Police Department had arrived at the apartment, where he found Oliver, her boyfriend Michael Patino, and their 14-month-old daughter, Jaslyn Oliver. Kite observed a couple of stripped beds and linens on the floor, a trash can with vomit inside it, dark brown vomit in a toilet, and crucially, a cell phone on the kitchen counter. Kite picked up the cell phone, and it was at that point, in that just realized opinion of a Rhode Island state court, that police proceeded to mangle a murder case and violate Platino's Fourth Amendment rights by viewing text messages without a warrant. Kite viewed a text message on the phone, which was owned by Tricia Oliver, reading, "What if I got to take him to the hospital? What do I say? And does marks on his neck? Oh my God." The message was sent from Tricia to Patino, and although the sending of the message apparently failed, there were other messages on the phone with profane language and references to punching Marco 3 times, the hardest of which was in the stomach. According to court records, Patino was arrested and charged with murder. Kite claims he picked up the phone because it was beeping, and he thought that it might help to get in touch with the boy's birth father. But yesterday, Rhode Island Superior Court Associate Justice Judith Savage threw out nearly all the evidence police collected from that point on, including the contents of a cell phone records, and communications provided by the Verizon, T-Mobile, and Sprint Nextel landline phone records, and even Patino's confession to the death of Marco Nieves. Savage said almost all the evidence obtained by police was tainted by the illegal search made by Sergeant Kite or the other legal searches and seizures of cell phones and their contents. Patino is fighting the case both on constitutional grounds and on the facts. He says that the injuries of the boy were an accidental result of horsing around. A privacy question that remains unsettled, however, is down here. Savage's decision in a state of Rhode Island versus Michael Patino is a bold and interesting one. Because the status of the text messages in criminal investigations remains unsettled in the U.S., Savage wrote, "This court finds that it is objectively reasonable for people to expect the contents of their electronic text messages to remain private, especially concerning law enforcement. Patino had a right to privacy for his text message conversations, whether police took them from his phone or Oliver's, and a right to privacy in the apartment because he frequently stayed there, making it one of his residences. Based on the tsunami of illegal evidence collected by the Cranston Police Department, this court grants defendant suppression motions and excludes the state's core evidence from being used at trial, including the text messages, all cell phones and their contents, all cell phone records, and critical portions of the defendant's videotaped statement and his written statement given to the police. The cell phone searches were illegal as warrantless or excess of warrants obtained, and as such, all of these searches and seizures therefore were unreasonable in violation of the Fourth Amendment," the judge wrote. Savage reasoned that cell phone contents are deserving of the Fourth Amendment protection against unreasonable searches and seizures because people generally keep them on their person at all times. Text messages are often raw, unvarnished, and immediate, revealing the most intimate of thoughts and emotions to those who are expected to guard them from publication, she wrote, further stating that the court does not find that the remote possibility that an unintentioned party will receive a text message due to his or her possession of another person's cell phone is sufficient to destroy an objective expectation of privacy in such a message. But Savage's decision is unlikely to be the final word on this topic. Savage herself noted that the U.S. Supreme Court has declined to provide guidance to lower courts. Even the United States Supreme Court has struggled with the legal challenges raised by emerging technology, most especially in the realm of cellular phones and text messages. She wrote, "Indeed, the City of Ontario, California, versus Kwan, that the parties asked the High Court to decide whether text messages should be afforded the Fourth Amendment privacy protection, but the Supreme Court declined. choosing instead to decide the case on narrower grounds. Just how private cellular communications are depends very much so on each court and police department, it seems. A ruling of state Washington in July found in favor of police officers who seized an iPhone for an unsuspected drug dealer and sent text messages on the device in order to locate and arrest one of his customers. Pretty interesting stuff right here, if I might say. So please make sure that you answer the key concept questions that come with that passage. And we're going to move on for the sake of this recording for the next contemporary case. Consider this, please. Your DNA is everywhere, but can police analyze it? Supreme Court weighing if we must live in sealed bubbles to maintain DNA privacy. Anybody who has watched a crime drama knows the trick. The cops need someone's DNA, but they don't have a warrant. So they invite the suspect to the station house, knowing some of the perp's genetic material will likely be left behind. Bingo. Crime solved. Next case. Do you know that a human sheds as much as 100 pounds of DNA containing material in a lifetime and about 30,000 skin cells an hour? But who owns that DNA is modern-day privacy issue before the Supreme Court. At its core, the issue focuses on whether we must live in a hermetically sealed bubble to avoid potentially having our genetic traits cataloged and analyzed by the government. The Supreme Court's justices will meet privately on February 27th to consider putting a case with this science fiction-like question on their docket. The dispute blends science, technology, genetic privacy, and a real-world unspeakable crime against a woman. The unidentified woman, in this case, was raped at her Maryland residence in 2006. Over the course of 2 years, the authorities interviewed as many as 20 suspects. They all voluntarily gave Maryland State Police a DNA sample. None of it matched the genetic material left on the crime scene. Then came another suspect, Glenn Rayner, a woman's former classmate. He voluntarily met with the police and said he wasn't the rapist, and refused to submit to genetic testing. During the interview, his arms rubbed against the chair, so police swabbed the chair's armrest. The genetic material they discovered matched crime scene evidence found on the victim's pillowcase and patio. Rayner moved to suppress the DNA evidence, arguing that the police breached his genetic privacy in the violation of the Fourth Amendment. In a 4-3 decision last year, Maryland's top court ruled against Rayner. Leaving one's genetic material behind is akin to a fingerprint. So no privacy invasion occurred, the majority reasoned. In the end, we hold that DNA testing of the 13 identifying Junk Loki with genetic material not obtained by means of physical intrusion into a person's body is no more a search for purposes of the Fourth Amendment than is testing of fingerprints or the observation of other identifying feature revealed to the public. Visage, apparent age, body type, skin color, the court ruled 4-3. The 3 dissenting judges said that the case sets a dangerous precedent. The majority's approval of such police procedure means, in essence, that a person desiring to keep their DNA profile private must conduct her public affairs in a hermetically sealed hazmat suit. Moreover, the majority opinion will likely have the consequence that many people will be reluctant to go to the police station to voluntarily provide information about crimes for fear that they too will be added to the CODIS database. The majority's holding and ruling means that a person can no longer vote, participate in a jury, or obtain a driver's license without opening up his genetic material for state collection and codification. Unlike DNA left in the park or a restaurant, these are all instances where the person has identified himself to the government authority. As human beings, we shed hundreds of thousands of skin and hair cells daily, with the cell containing information about who we are, where we come from, and who we will be, said Jennifer Lynch, a senior EFF staff attorney. The court must recognize that allowing police the limitless ability to collect and search genetic material will usher in future where DNA may be collected from any person any time, entered into a checked against DNA database, and used to conduct pervasive surveillance. Another interesting case, for sure. So at this time, once again, you may either pause the presentation and answer the questions, but for the sake of this recording, we will go on to the third and final contemporary case. This case is entitled 610,000 Case After School Spies on a Student. Please listen carefully to this. At the beginning of the 2009-2010 school year, a high school district in Pennsylvania issued individual MacBooks to each of its 2,306 high school students. The laptops were for both in-school and at-home use. It was part of the school's one-on-one initiative. The school loaded each student's computer with the remote activation and tracking software. That allowed school officials to secretly take photographs through the webcam of whatever was in front of it and in the line of sight, and send the photographs to the school server. After sending the image to the school servers, the laptop was programmed to erase the sent file created on the laptop. That way, there would not be any trace by which students might realize that they were being watched or photographed. On October 20th, 2009, the school district officials knew Blake J. Robbins, a sophomore at Harrington High School, was in possession of his laptop and had taken it home. They also believed Robbins was selling drugs. On that day, they nevertheless decided to begin capturing webcam photos and screenshots from his school-issued MacBook by activating its camera covertly. Over the next 15 days, the school district captured at least 210 webcam photos and 218 screenshots. They included photos inside of his home of Robbins sleeping and of him partially undressed, as well as photos of his father. The district also snapped images of Robbins' instant messages and video chats with his friends and sent them to his servers. The lawsuit claimed that the district's use of webcams violated the U.S. Constitution's Fourth Amendment right to privacy. Many students said that they mostly use their laptops in their bedrooms and rarely turn them off. Karen Gottlieb, whose daughter attends the school, said, "I just received an email from my daughter who is very upset saying, 'Mom, I have my laptop open in my room all the time, even when I'm changing.'" Savannah Williams, a sophomore at Harrington, said that she always keeps her computer open, its webcam exposed, and she's changing in her bedroom. In the bathroom, when she's taking a shower, she said, "I was like, 'Mom, I have this open all the time. This is disturbing.'" On October 2010, the district agreed to pay $610,000 to settle the Robbins and Parallel Hassan lawsuits against it. Students felt that as though their Fourth Amendment right to privacy had been violated in a strong case in court. However, the school district claimed that because the computer was owned by the school, there was no reasonable expectation of privacy, similar to a locker. On The Early Show, Blake Robbins and his parents discussed their case further. Blake said he feels better now that it's all over. He explained, "At first I couldn't really say anything because my assistant principal was beating me up for supposedly selling drugs. At first it didn't occur to me, and then eventually I thought it was shocking that they would do this." Blake said that the green camera light would sporadically turn on and off. Michael Robbins said a photo of him and his son's computer actually ended up on the local news in Philadelphia. Michael recalled, "They said I looked like Gene Simmons without makeup." As for the $610,000 settlement, a significant portion goes to legal fees. Another student who sued will receive $10,000, but Blake will receive $175,000 in a trust. He will receive $25,000 up front. Blake plans to get a car, and when he's 18, plans to invest the trust money. So as you guys can see, before we answer the questions and before we formally end, the Fourth Amendment and some of the other amendments that stem from it in terms of rights of the accused are rather complex and complicated, especially when you try to consider the everlasting question of who's innocent and who is guilty. So I hope that you found this reading part of the presentation helpful. If you have any further questions, please reach out for clarity and detail and help. Good luck.